the legal analysis yields that Mr. Pawlowski must be acquitted. It's very... it has not been established in previous jurisprudence that the conduct that Mr. Pawlowski engaged in could secure a conviction. Right. This conviction that he has suffered is first of its kind in Canada.
Adam Soos here for Rebel News, looking back at the draconic COVID-19 measures that saw churches shuttered and pastors arrested. Pastor Artur Pawlowski was undoubtedly one of the most prosecuted men in this nation, all because he insisted on feeding the poor, refused to shutter his doors, and finally dared to speak, as preachers sometimes do, to some truckers in Coutts. Pastor Artur Pawlowski has secured legal victories on virtually all of the charges that have been brought against him, extending from COVID-19, except for the mischief charge that resulted from him speaking at Coutts. And in the minds of many, that charge was in fact one of the flimsier cases that has been brought against him. Fortunately, as we know, Pastor Artur Pawlowski is not one to back down from a fight, nor is his legal counsel, Sarah Miller of JSS Barristers, who, thanks to your donations at saveartur.com, has been working tirelessly on Pastor Artur's behalf. For an update on the appeal to this latest mischief charge, I'm very happy to be joined now by Sarah Miller herself.
So when I decided to come here, I'm risking to be arrested at every moment, everywhere I go. The criminal charges on me, left and right, we lost count of the charges I have right now. But I decided to come here because I believe that the eyes of the world are fixed on this place, right here. Amen. Yes, this little pitiful piece of land. And the eyes of the world are fixed right here on you guys. You are the heroes of the solidarity movement.
Well, thank you so much again for joining me, Sarah Miller of JSS Barristers. I suppose my first question for you, it's been a while since we've had an update, and we are going to get into the details of the sort of advancement on the appeal process on the charges that Pastor Artur Pawlowski is facing. But first off, if we could just sort of touch on how many charges you've sort of won on. Like, Pastor Artur Pawlowski has just been knocking them out of the park, and in a great deal thanks to the work that you've been doing. So can you recall roughly, I mean, obviously not everything's going to come to mind, how many cases Artur Pawlowski has been successful on?
So quite a few Public Health Act tickets throughout the course of the pandemic, either thrown out or withdrawn at variable times. Charges for civil contempt or an application for civil contempt and criminal contempt, both, one successful in appeal, one ultimately withdrawn. Charges for breach of probation, ultimately successful, and charges for trespass and interference with ordinary use of property, he was actually acquitted on, and all success since 2020 for Mr. Pawlowski until his mischief conviction down in Lethbridge.
Yep. Now, one of the cases before, it had to go to appeal, correct? So there was a successful appeal on one prior instance. Which one of those cases was that?
That was the civil contempt. So the civil contempt, Alberta Health Services commenced the civil contempt application. He was convicted of civil contempt, sanctioned. That was the order which compelled him to say certain things when speaking in public and imposed a significant fine on him and his brother David. And that is what was appealed a while ago now, and the conviction on the civil contempt was overturned.
And so these appeal processes, as we saw, can really work. It's not just kind of putting up a fuss. We've seen these succeed. We've seen these succeed specifically with Pastor Artur Pawlowski already.
Yes, absolutely. On that civil contempt, and with prior counsel that has represented Artur Pawlowski in prior years.
Now, remind us of the details for folks who haven't been following this story of the current case, the current charges against him. What incident do they stem from?
So February 2022, or end of January, beginning of February 2022, for about 2 weeks, there was a protest going on in Coutts, Alberta, where a number of what I'll call truckers set up down there. And one afternoon, Artur went down and spoke to them at what's called Smuggler's Saloon, I believe. It's a pub or something down there. And so he spoke to the crowd for about 20 minutes. The recording is 19 minutes and change, then returned home. And a few days later, he was arrested in his front yard for what ended up being inciting mischief, interference with the Critical Infrastructure Defense Act, and breaching his release conditions. Keeping in mind that his release conditions arose from the criminal contempt charge that should have never been laid, in my opinion, at least should never have been laid, and was ultimately withdrawn. So he was under conditions to keep the peace that should have never been imposed, in my opinion. And he was convicted on all three down in Lethbridge last year.
So I suppose we'll get into the grounds of the appeal, and that'll touch on some details of the case. But upon being found guilty, I believe from previous instances, Pastor Artur Pawlowski had spent his 78 days incarcerated. I know there was one 51 or 52-day stretch, and then there was a number of other instances. And then he was basically sentenced to 60 days, and it acted as time served. Was all the time served from that one incident, or was it kind of cumulative from a number of arrests?
No, so the other time that the other instances when he had served time, those kind of just get washed away as those get resolved. So when he was arrested from the inciting mischief charge in his front yard, he was detained at that time, and he ended up spending 51 or 52 days in custody and getting time and a half credit for being detained before trial had ended. And so his sentence, although quite outrageous compared to other people who have engaged in similar activity, at least when they've actually participated in the protest. He was sentenced to 60 days, but it was all time served. He had already served that time prior to trial prior to his conviction.
So now the update that we have for folks is that the factum has been filed. Is that correct? Or it will be? For those of us who aren't lawyers, what does that mean?
Yeah, so after he was convicted and sentenced last year, we commenced an appeal process, filed a notice of appeal with the Court of Appeal in Alberta. And now, as of yesterday, we have filed the factum, which is the written argument that gets submitted to the Court of Appeal to explain why the lower court erred. Or if you're the respondent, why the lower court didn't err. But since we're the appellant, we're saying why the lower court erred.
So it isn't simply a restating of facts. This is the actual, this is why we think there was a mistake here. Are you at liberty to discuss some of those arguments as to why you believe there was a mistake?
Yeah, so the trial judge found that the speaking itself was inciting mischief and not protected by Section 430 sub 7. Section 430 sub 7 of the Criminal Code says there is no mischief if you attend at a place simply or only to communicate information. And that section has been interpreted by the Ontario Court of Appeal. And the Ontario Court of Appeal was very clear that obviously you only even need to consider that section when the language and the information that has been communicated triggers the prior section, triggers mischief.
Right. And
so then if it is inciting mischief, then you consider, well, did that person attend that place for the purpose of only communicating information? Did they do something more? And the trial judge said, well, the more was inciting mischief, which is simply circular. It's illogical. It doesn't, why have that section if all you're doing is inciting mischief and that's all you're talking about? Well, then that section is meaningless. Right. So we say that's an error. Another error is we have argued throughout the trial that the criminal code needs to be interpreted where there's ambiguity, such as communicating information. What does that mean? That ambiguity needs to be resolved in favor of constitutional principles. Freedom of expression, freedom of gathering, those types of things. The trial judge found in his decision that to argue constitutional principles required a constitutional notice. And this is going to be a little bit nitty into the legal analysis, but we say that's wrong. Constitutional principles are used to interpret statutes without constitutional notices or charter notices. And when you are seeking a remedy such as Section 24, Section 52, so a stay of proceedings, or to have the actual legislation changed in some way, then you need a charter notice and you need to give notice to the government that you're going to be doing that. But in this case, we're just saying interpret what's there already. We're not looking for a constitutional remedy such as changing the legislation. And so we don't need to file a constitutional notice, and you do need to consider those principles when you're interpreting the criminal code. And the final main error is section 429 sub 2, which says if you have a legal justification for conducting yourself in that way, then there is no conviction. And that has been interpreted by other courts throughout the country, but hasn't been spoken on in Alberta, but in other jurisdictions that means if you're there to express yourself and exercise your freedom of expression, then section 429 sub 2 is engaged.
Now, many people have sort of talked about all the charges he's faced. This one, and I'm not putting these words in your mouth, but it seemed like the flimsiest. It seemed the least likely to sort of stick. So is there a hope that this will be resolved fairly quickly? And in addition, I suppose, I don't know if this is how the courts operate, but is there any element of sort of hindsight where obviously in retrospect some of these measures were draconic and unnecessary? Does that factor in at all?
So, mischief in the criminal code is used against protesters across the country for all sorts of things that can be sympathetic or not. I wouldn't say that it's draconian. I would say in this particular instance that the legal analysis yields that Mr. Pawlowski must be acquitted. It's very... it has not been established in previous jurisprudence that the conduct that Mr. Pawlowski engaged in could secure a conviction. Right. This conviction that he has suffered is first of its kind in Canada. So I would say the circumstances around it, the person that Mr. Pawlowski is certainly, can inform the conduct of police and other actors in the system. I have a lot of faith in our Court of Appeal system. Errors happen. That's right. Why we have appellate courts. So I do believe it will be fixed upon appeal.
And what's the sort of timeline for folks who are interested?
So we just filed our factum yesterday with the Court of Appeal. The Crown will be filing their factum in response in June, and then we're being heard in September. After the Court of Appeal hears us, that panel of 3 judges has to go back and come up with a decision, either a unanimous one or 2-1. Right. But they have to come up with a decision, and they're going to almost certainly, draft that decision, and it will take some time to do that. And so we're probably looking at at least a few months after September before a decision is issued by the court.
Well, thank you so much for your time. We love that nitty-gritty legal insight that only you can bring. I'm sure our viewers will be happy to see you again. And thanks for all the work you're doing on the incredible legal efforts for Pastor Artur Pawlowski. For those of you at home looking to support Pastor Artur Pawlowski, you can do so at saveartur.com. And as always, I want to thank you all so much for tuning in. For Rebel News, I'm Adam Soos. While many have had the opportunity to move on from COVID-19, some, like Pastor Artur Pawlowski, are still facing massive legal battles. If you want to let Pastor Artur know that you haven't forgotten about him, you can do so by chipping in at saveartur.com.